So today we are having the last session of this cybersecurity, not cybersecurity, cybercrime and security part. And we will be discussing about the cybersecurity. Just a second. Okay. I'll share the screen with you all and we will just start. Can you all see this PDF?
Yes,
Okay.
it's visible.
So this is going to be the topic for us today, which is our
Excuse me,
cyber.
ma'am.
Yes. Yes. Yes.
I think your mic has some problem as the sound gets interrupted. Please just once check it. We are not getting sound clearly. Thank you.
Okay. I'll try to check it.
It will get better.
Better.
Yeah, previous lecture it was the same problem, so it will be get better.
Okay. It will get better with the time. Okay. So these are all the things that we are going to learn today. What is the cyber crime? What are all the penalties and the compensations, types of the offenses, what is cyber forensic? And after that, we are also try to cover the intellectual property rights in the cyber space. What are all the types of the intellectual property rights are existing, and what are all the things which are applying for the cyberspace. So these are all the topics that we will be discussing. Yes. You want to say something, Arif?
Excuse me.
Yes.
The sound is not clear.
The sound is not clear. There's a lot of problem. How it is now?
Ma'am, regarding that sound, some aberrations are there in your sound.
Sir, I have removed the earphone. How it is now?
Okay, yeah, it is same.
Same.
And then you are using the mic of the laptop or earphone?
Sir, now I'm using the mic of the laptop. Earlier, I was using the earphone.
Okay. Yeah, but it is more or less same. Yes.
Okay.
So anyway, it's not that disturbing. It is not that much.
Because there is no another noise over here. It's just
there is no other noise. Just it seems that some wire is loose. It looks like that, but yeah, it is not the case. It may be something else.
Possible, sir. Yes.
Yeah, you can go ahead with anything. Means both are same.
Both are same. Then I will use the earphone. This is better for me.
Okay, ma'am. Yes.
Okay, sir. I just hope the voice is going to be better after some time. Okay. So if it's not, then do let me know. So I was telling you, we are going to discuss about the cyber crimes, and we are also going to describe the various kind of the penalties and the compensations. And then after that, what are all the offenses and what are all the punishments for the offenses. So first of all, let us define and describe the term cyber crimes and what are all its classification. So cyber crime is mainly any kind of the crime that is being performed with the use of the computer system, right? Any kind of the crime that is being performed with the use of the computer system and the another kind of the computer resources along with the internet comes under the cyber crimes. Now, it could be of two kinds. It could be of the type of the hacking also, and it could be also of the type of stalking. Hacking is generally when somebody wants to affect the computer system of someone, then that comes under the hacking part. And when the intention is to affect the people only, then that comes under the stalking part. I think this is also written over here in the two examples that are being given. So there are mainly two important targets for the person who wants to do the crime, and with the help of the computer system only. The first is if anybody wants to hack all the information which is present onto your computer system and then alter the information, or then just wanted to do any kind of the modification into with the information, that comes under the hacking part. In the stalking part, it's when the motive is to attack the person. In that case, the stalking comes into the picture. But stalking is also performed onto the cyberspace only. You stalk the person on their various profiles that is being present onto the internet, and then you make the crime according to by seeing the pattern of the people, or by seeing the pattern of the person to whom you are stalking. So these are the two kinds of the cyber crimes which are being present. Now, there is a difference between the cybercrime and the traditional crime. In the case of the cybercrime, it is always easier to detect, to investigate, and to prosecute the criminal or the possible criminal. Whereas in the case of the cybercrime, it is not very easy to just find out the person who has made that crime. That is why we have made the cyber laws, so that if any kind of the crime that is being performed onto the internet can be detected and can be investigated, and then after that the proper actions can be taken out. Now, the thing is that the traditional crimes can also be conducted by making use of the internet or any another computer technology. For example, we have a number of the crimes which are happening. It could be the case of the defamation, forgery, identity theft, any kind of the terrorism activities also, cyber stalking, and many more are also available, which are making use of the computer systems but performing the crime which are traditionally being performed. But in those crimes also, the computer systems or use of the internet is being done. So that is the kind of the thing between the cybercrime and the traditional crime. You just try to understand that cybercrimes are cybercrimes only, but even if the traditional crimes are happening, then also the use of the cyberspace is being made, right? So we all can see how much important is this cyberspace and how much important for all of us to protect this cyberspace from any kind of the crime. Because if that cyberspace is being used for this kind of the purpose, then it is going to be double of the effect, because traditional crime is also making use of the cyberspace only, not only along with the traditional thing which is being performed by the traditional criminals. So all those people are making use of the cyberspace also. So it is always very, very important to protect or to make laws for the cyberspace or for anything or any crime that is being performed onto the cyberspace. That is what is coming inside the cyber laws. That is from where the term cyber laws have come, because before that we need to understand that cyber crimes are existing, and then for combating these cyber crimes, we need to have the cyber laws. So before moving on to the various kind of the cyber laws, we must understand that in the case of the traditional crimes, the criminals, what happens? The criminals usually leave behind some kind of the proof. It could be in the form of the fingerprints or it could be any of the physical proof. There are the better possibilities of leaving the proofs behind whenever the crime is being performed. Whereas in the case of the cyber crimes, the cyber criminals commit their crimes by making use of the internet. And in this case, there are very, very less chances of leaving any kind of the physical proof. It is very difficult for the people who are all related to finding out who have performed the cyber crime to actually find a person who has made this crime. Because as in the case of the traditional crime is happening, that the person is leaving the physical proofs, it is not happening into the case of the cyber crime. So it is always easier to find out the physical proofs, but it is not happening in the case of the cyber crime. So it becomes difficult to catch the person or to catch the criminal in the case of your cyber crimes. Now we have classified the cyber crimes generally into the different groups. So these are the different groups. 4 types are there. First is your crime against the individual. Second is your crime against the property. Then we have the crime against the organization. And the fourth one is a crime against the society. So these are all the 4 classes into which the cyber crimes are being divided. So what comes under the crime against the individuals are any kind of the harassment, any kind of the cyber stalking, defamations. It could be the cheating or the email spoofing or the fraud. And all these kinds of the crimes comes under the crime against the individual because they are actually pointed towards the individual. You are harassing an individual only. You are cheating an individual. You are stalking an individual. You are spoofing or you are sending the spoofed mail to the individuals. So or you are doing the fraud with an individual. For example, you must be getting a various kind of the phone calls which are saying that kindly tell me your ATM pin. You have won this much of the lottery. So that is a kind of the fraud which is being trying to happen with you. So all these kinds of the crime, which again come into the category of the crime, all these kinds of the crime comes under the category of crime against the individual. When only a single person is being affected or when the crime is performed only on the single person, then he comes under the category of the crime against the individuals. Now, talking about the second types of the class or the category, it is basically crime against the property. Crime against the property means whether you are trying to infect any kind of the computer system or you are just trying to infringe to the intellectual property, then this kind of the crime comes under the crime against the property. Now, property could be your physical properties or your intellectual properties. Means the property could be your tangible or the intangible properties, which includes physical properties means whether you are transmitting the viruses or you are just trying to access anybody's computer system when you do not have the authority to access that computer system. So that comes under crime against property. Or when you are just trying to thief somebody's files which are being present onto anybody's internet by making use of this technique which is called as your internet thefts, right? And second category of the crime against property is your infringement of the intellectual property. There is any kind of the intellectual property, whether there is any kind of the copyright is there, patent is there, trademarks are there, design is there, right? Geographical indication is there. And what the person is trying to do, the person is trying to infringe the intellectual property of the another person. He's trying to use or he's trying to show that this property belongs to me. Then that kind of the infringement is your crime against the property. If any activity of this kind is happening, that means crime against property is being happening. Now, the third kind is your crime against organization. When the target of the criminal is to affect the entire organization, then that kind of the crime comes under the crime against organization. It could be the cyber terrorism within the government organizations, possession of the unauthorized information, or the distribution of the pirate software. For example, any company have the original software. Now, what the criminal is doing, he has created the pirated software of that company and now distributing that pirated software everywhere. So that also comes under the crime. Crime doesn't include only the traditional crimes. Crime also includes the frauds kind of the thing. It also includes the transmission of the viruses. It also includes the distribution of the pirated software, right? Any of the activity that is not legit or that is not legitimate or that is not legal, then that will come under the crime or that will come under the cyber crime. Now, the last kind of the category of the cyber crime is your crime against the entire society. So in this case, when the person is targeting the entire society or a portion of the society, then that kind of the crime is going to be called as your crime against the society. It includes the child pornography, financial crimes, sales of unlawful articles, trafficking, forgery of the records, gambling, etc. So all these examples or all these types of the crimes are coming under the crime against the society. So these are all the 4 kinds of the crime which are being which are being classified, and we say that cyber crimes can be of 4 types. It could be the crime against the individual, it could be the crime against the property, it could be the crime against any organization, or it could be the crime against the society. But all these crimes are happening with the help of the internet only, and all these crimes are being performed in the cyberspace only. So whenever the crime is being performed in the cyberspace, then that kind of the crime is called as your cybercrime, and these are all the various classes of the cyber crimes. Right? Understood?
Yes, madam.
Yeah. Okay.
Okay.
Yes.
Okay. So the definition is clear. Moving ahead. So in this entire cybercrime thing, we are going to be understanding a number of the laws also. So where there are various sections that are being written into this PDF, which are present. So we are going to try to cover the important ones because a number of sections are being written. So you need to learn and you need to know about the what are various sections which are really important, which are actually important, which the laymen also know about. That if we are going to perform this kind of the action, then it could fall into the category of the crime. Right? So next topic for us is your penalties and the compensations. What are all the kind of penalties that are being imposed onto the person who performed the cybercrime, and what are all the kind of the compensations which are available? So here, when we are talking about the sections, we are talking about the Information Technology Act 2000, which is an act that is being imposed in India, right? So all the sections, wherever this term section, that means we are talking about this Information Technology Act 2000. So what it provides us, it provides for the instances where the wrongdoer is liable to pay the damages by the way of compensation to the affected party. So if there is a person who has made a cyber crime, then what are all the penalties and the compensation that person has to pay to the affected party or to the party who has been suffered by his crimes. So we are going to discuss about all these sections. Now, section 66 of the Information Technology 2000, however, provides that if any person dishonestly or fraudulently does any act referred to in section 43, he shall be punishable with imprisonment for a term which may extend to 3 years, or with the fine which may extend to 5 lakh rupees, or with both. Okay, so section number 66 is depending on to your section number 43 to 45. Right? There are certain points which are being present into your section 43 to 45. What it is saying that if there are any kind of the instance of wrongdoing, then he has to pay certain kind of the compensation to the party. He means the person who has performed this crime, right? Now, section 66 of the Information Technology Act 2000 is depending on to the section 43 and 45, and what it is saying that if any kind of the dishonesty or the fraudulent is being performed, then the person either has to serve the jail, or either has to go to the imprisonment, or he has to pay the fine of rupees 5 lakh, or there is a possibility of both the things that can be imposed on that person. So in the case of penalty and compensation, there are always two kinds of the things, right? There are 3 possibilities. One is to pay the fine, right? That for this kind of the offense, the person has to pay this much amount of the money to the affected party. Second could be he has to serve this much of the time in the prison. Third kind of the thing is that both the things are possible, that he has to serve his term into the prison also. Along with that, he has to pay this much of the compensation to the party also. So these 3 possibilities are possible under the section 66 of the Information Technology Act. Now, the section 43 of the Information Technology Act provides that any person who, without permission of the owner or any another person who is in charge of a computer system, computer network, commits the following acts, shall be liable to pay the damages. Now, these are all the kinds of the acts which are being written over here, and they are actually like five in numbers, and all the points have another sub point inside them. So we are going to learn about what all is written into the section 43. First of all these things are being written into your section 43 till here, and then we are going to see what is being written into the section 43 and then the section 45 and all section 46 also we are going to just see, right? So we are going to learn only the important points about this. So what is being written in the case of the section 43? First thing is section 43 is talking about if somebody is accessing someone's computer system without his permission, means if there is a kind of unauthorized access of the computer system or of the computer network also, then these are all the things which comes under this, and he is liable to pay the damage if any kind of thing happens to the affected party. So what are all the points coming inside this? First is your access or secure access, then download the copies or extract any of the data. Accesses or secure accesses. First point means he is not an authorized person to access, but then also he's accessing the computer system, and even he's also accessing it, the secure accesses which are being, or the any kind of the security that is being imposed onto the computer system. Second is if he's downloading or making the copies or extracting any kind of the computer data which he is trying to, which he's accessing. Even if he downloads, he makes the copies or he extract any data, then that also comes under the offense. Third point is introduces or causes to introduce any kinds of the contamination into your computer system. Means he just try to infect your system with any kind of the malicious software, then that also comes under the effect. Means he's not downloading the copies or he's not extracting any kind of the data, but what he's doing, he's just putting a file that includes a virus and just put that file or install that file into your computer system. That is also a kind of an offense. Then this C part is again being explained. What is coming into the another part? Just a second. Now, in these two definitions, there has been an explanation of the computer virus, means what it means by computer virus. The third point is saying that by any means to usurp the normal operation of the computer system. Obviously, it is being written or it is being understood by us that there shouldn't be any means that he wants to infect your computer system, he wants to affect the normal operation of your computer system, he wants to modify, destroy, record, transmit the data or the program inside your computer system. Then there are two definitions of the computer virus and what are all the kind of the damages that can be done with that computer virus. Then after this C point, we have got this D point. What it says that damages or causes to be damaged data, computer database or any other program. Again, there are the detailed definition of each and every word inside these points. Just a second. I'll just take a gap of few minutes. I'll be coming back. Okay. Don't go anywhere. Don't leave the meeting. Fine. Okay.
Okay.
I'm just back, Peter. Sorry for this delay. You all can hear me now?
Yeah.
Yes, ma'am.
Okay. So we were talking about all these. Section number 43 of the Information Technology Act, right? So I was explaining you this topic. All in all, what is happening inside these acts is that they have explained each and every point in so much of detail that there is no possibility of any kind of the confusion that a person can save from. You can see it from here also that even if the term computer virus is being written, there is a proper definition of the computer virus that is being presented into this section 43, that what will be considered as the computer virus. You can see that the computer virus means any computer instruction, information, data, or program that destroys, damages, degrades, or adversely affects the performance of a computer resource. So just see in how much detail each and every word is being written, so that not even a single word is being missed and then can be used to save or to protect the cyber criminal. Then after that, in the point D, what we are seeing that damages or causes to be damaged data, computer database, or any another program. So damages or the causes to be damaged is also considered inside this section number 43. Then after that, small number 4 of this section provides damage means. Now, if we have used this term damage, now in this part, they have explained what damage means is, right? The term, even the term damage is being explained so much that damage will include either the destroy of the information, either the alteration of the information, addition, deletion, or any kind of the modification or the rearrangement in your computer system. Then if the computer system, if any kind of the modification is made such that the disruption has caused into your computer system, that will also come under your section 43. Then after that, denies or causes the denial of access to any person authorized to access by any means. There should not be denial of access also, right? If there happens a denial of access, that will be covered under this section. Then we have the point number G, which says that provides any assistance to any person to facilitate access in contravention of the provision of this act, rules, or regulations made thereunder. Now, all these things which are being presented under, there shouldn't be any kind of the assistance from the insider to the outsider. If somebody is being present inside, for example, inside an organization who is helping another person or who is providing any kind of the assistance to the person, then that person will also be coming under the offenses only. So nobody can provide any kind of the assistance to any person. Now, we have after that, if there is any kind of the steal, conceal, destroy, alter, destroys, deletes, any kind of the word, you can see, you just name the word and you will just find out all these words are being present over here and explaining to them that these are all things which are going to become under the crime only. There wouldn't be any point that would be like used for saving from the crime that has been performed. Means you cannot take the another route in order to get saved by just altering the words, by just saying that these are all the words, I have done this, but the meaning of this is not like that. That is why all the definitions are being written over here, that if we are making use of the word damage, if we are making use of the word virus, if we are just using any of the word, that includes all these points. So that is being happening, right? Now, Section 43A of the Information Technology Act 2000 provides for the liability for the compensation of a body corporate for failure to protect the data. Now, compensation, if it means that any company and includes a firm, sole proprietorship, or another association of individuals engaged in commercial or professional activities. Now, they have defined what this term organization or the body corporate means. Now, what it is saying that the liability for the compensation is also being applied onto the corporates or the organizations also, if they have done if they have been failed, then they also had to make some kind of the compensations, because there are certain kind of the organizations which are storing the data of the common people, right, which is very, very important. So if that particular organization fails to protect the data of all the people, then that organization also being liable to pay for the compensations, right? Now we are going to see what is being explained into the section number 43. I hope all these points are being clear, because they are like very, very wide in nature, right? Section wise, it is like the entire law book is being written over here. Now what you have to do is just to pick up the important points from all these points which are being written, but you must know about all these points. For your examination purpose, you need to pick up the important points, but actually as a user of the internet or as a cyberspace user, you must be aware about all these points, what are all being written under which section, and what are all the punishments that are going to be given to the person if he has made any kind of the offenses which comes under this category. So any kind of the alterations, any kind of the modifications, any kind of the damage to the data, any kind of the unauthorized access, any kind of just installing the viruses into your computer system, all these things comes under the section number 43. Now moving further on to the section number 44, it provides for the penalty for the failure to furnish the information or return, etc. Right? Section 43 talks about your penalty part. What it says that if any person who is required under this act or any rules or regulation made there under 2, furnish any document, return or report to the controller of the certifying authority, fails to furnish the same, he shall be liable to a penalty not exceeding 1,50,000 rupees for each such failure. So in the section number 44, we are talking about all the kinds of the penalties, right? I'll just make them highlighted. What it is saying that if the person who is required under this act, means if he has made any kind of the offenses which comes under the Information Technology Act, then he is liable to pay 1,50,000 rupees for such kind of the failure. Second, file any return or furnish any information, books or another document within the time specified. Maintain the books of accounts or records, files to maintain the same. He shall be liable to penalty not exceeding, means if the person is not able to save or maintain the books of accounts or records or fails to maintain the same, then he needs to pay the penalty not exceeding 10,000 rupees for every day during which the failure has continues. So the section number 44 is talking to us about the amount of the penalties. The penalty amount could be of 1,50,000 rupees. It could also be of rupees 10, not exceeding 10,000 for every day, means 10,000 rupees per day until and unless the failure is being pertaining into the particular organization. So section number 43 or section number 44 is talking about the penalties or the amount of the penalties. Now after that, we have also got the section number 45, which could be easily understood by you all people, which says that the maximum penalty in the case of the section number 45 is your rupees 25,000. It talks about your residuary penalty, means there is the kind of the penalties which comes under your residuary penalties, and the amount of that residuary penalty would be rupees 25,000. Now adjudication is the next point which is talking about and which comes under your section number 46. Section number 46 is adjudication, which talks about the appointment of the authoritative person, means a person who is related to the central government and who has held the rank of the director into the central government or similar into the state government, is made as the adjudication officer for holding any kind of the inquiry. Means, for example, there is a situation in which there is a need of a committee, right? So committee is going to sit and that committee is going to check whether such kind of the offenses or the cyber offenses have been performed or not. Now in that kind of the situation, there is this person who has been given as the post of adjudicating officer. It is being written over here, adjudicating officer, right? Now, what will be the responsibility of this person? The responsibility of this person is to claim for the injury or the damage that has been performed, and in that case the amount should not exceed rupees 5 crore. Means adjudication officer is basically related to a particular committee that is being formed in order to check that whether the cybercrime is being performed or not. Then he has to decide about the amount of the penalty that is going to be imposed onto the particular organization or whosoever is being an offensive in that kind of the situation. Means it's not like that it is before moving on to the court or before moving on to the tribunal, there is a previous step in that case which is called as your adjudication. You all can read it from here that who is the adjudicant. Adjudicant is the person, or it authorizes the central government to appoint any officer not below the rank of a director to the government of India or an equivalent officer of a state government to be holding that kind of the inquiry. Means that person is going to hold an inquiry and then he has to decide the amount, that this much of the amount is being decided, and all these points are discussing about whether the penalty of 5 crore, whether the penalty should exceed the 5 crore or it should not exceed 5 crore, and it is talking about what are all being written under the Indian Penal Code. So all these things, or the Information Technology Act that we are talking about, or all these sections which we are talking about according to the Indian Penal Code or according to the Information Technology Act of India only, right? Then next we have the appellate tribunal. What this appellate tribunal is, this is a kind of the special court or the committee. For example, there is a court which has given a certain kind of the decision, right? Now if the person is not satisfied with that kind of the decision, what he can do, he can move on to the appellate tribunal. Appellate tribunal is basically a special kind of the court or the committee that is being formed to reconsider a decision made by the another court or the committee. Means for the reconsideration of the decision that is being made by another court or the committee, an appellate tribunal or a special court is also being assigned. Means if there is a certain kind of the decision that is not in favor of the person, then that person can even move on to the appellate tribunal, or that person can even move on to the special court, right? So that comes under this appellate tribunal. Now we have to see that where this appellate tribunal is being written. It comes under the section 62. You all can hear me now?
Yes.
Yes.
Okay. So sometimes I need to check on. So it comes under the section 62, provides for the appeal to the higher authority or the higher court. I hope it is very much understandable that whenever we wanted to just go further with the decision, that we are not satisfied with the decision, then we move on to the another higher court or the special court, and there are certain kind of the restriction in that case, that you can move on to the higher authority within the 60 days from the date of communication of the decision by the previous authority. Means under the 60-day time period, you have to, if you wanted to, you can move on to the another court or the special court or the high court, right? Next is what are all the kind of the offenses, or what is considered under the offenses. Offenses means the crimes. Following acts are considered as offenses under the act. Act matlab Information Technology Act 2000. Here we are talking about the Information Technology Act. So all these activities that we are going to see, they will be considered as the crimes, or they will be considered as the offenses. What are all these activities? For example, section 65 provides for the tampering, concealing, destroying or altering any computer source document intentionally. If this is happening, then there is a penalty of rupees 2 lakh. Then there is a penalty up to rupees 2 lakh or imprisonment of up to 3 years. And the third condition is your both the things can be imposed. So section 65 explain about the amount of the penalty, and also about the imprisonment in the case of the tampering of the data, or there is a concealing of the data, that you have steal the data, or you have just steal the data and hide that data. Now, the organization to which that data belongs to cannot find that data. So that comes under your concealing of the data. Or what you have done, you have just destroyed the data. You have just deleted the entire data. Or what you have done, you have made the changes into your data or into the data. So if any of all these things are happening, then, and if you're caught, then what could happen to you? Then in that situation, you need to pay rupees 2 lakh or serve the imprisonment for the 3 years, or both the things can happen. Then after that, what is happening in the case of the section 66? It provides for the dishonestly or fraudulently doing any act as referred in section number 43. Section number 66 mainly deals with the dishonesty or the fraudulent. Means you wanted to just do the fraud with any of the party, or you just wanted to do the fraud even with an individual or with the entire organization, with the aim of, obviously the fraud is being done with the aim of the dishonesty only. Then if you are just even stealing the information, or you're just stealing the money, or you're just doing any kind of the fraud, in that case there is a penalty of rupees 5 lakh or imprisonment of rupees 3 years, or both the things can also be put on to that particular person or the organization. So the penalties, amount of the penalty is being rising in the case of the fraud or dishonesty, and that is risen up to rupees 5 lakhs, and the imprisonment has been for years 3, right? Or both the things can also be imposed. Now, after that, what the section 66A is doing, we have got the section 66, and it has got the two important section under this. One is 66A and another is 66B. 66B is being talking about a very important landmark case that has been happened between the Shreya Singhal versus the Union of India case. The court found it as a violation of the freedom of the speech and expression guaranteed under the Constitution of India. So the Constitution of India provides you the freedom of speech and expression. In that case, there is a violation of this kind of the freedom. So there is a violation of the freedom of speech and expression. So this kind of the violation comes under the section 66A. After that, section 66B is talking about, provides for the dishonestly or fraudulently receiving or retaining any stolen computer. Okay, now somebody has stolen the computer resource or the communication device, right? Now, if you have received, if you are even receiving it from somebody, means, for example, I am that person who have done the dishonesty, who have done the fraud among any organization, right? I have taken the computer resources and the communication devices with me. Now what I'm doing, that I'm going to the market now and I'm just selling that particular computer resource to the another person. Now even that receiver is going to be an offense. Even that receiver is going to pay the penalty, that why you have received, why you have not checked it whether that particular computer resource or that particular communication device is being steal from somewhere, or that is original. So even if you have received it, then there is a penalty of rupees 1 lakh and the imprisonment of 3 years, or both the things can be imposed onto that particular person. So you have to be very, very careful in the case of receiving also. Even if you haven't done the dishonesty, even if you haven't done the fraud, in that case also, but what you are doing, you are receiving it, right? You are receiving the stolen computer resource, you are receiving the communication device. In that case, you are being considered as the person who have made certain kind of the offense, right? So in that case, the penalty which you have to pay is rupees 1 lakh and I will not say or the imprisonment of 3 years, or both the things, right? So that is coming under the section 66B. Understood?
Yes, ma'am.
Okay. Now, all these are the parts of the section 66 only. We have got the section 66A, 66B, 66P, C, and the 66D. All of these sections are basically explaining you what is the kind of the offense that is being performed, and what are all the amount of the penalties that needs to be paid by that particular person. It could be the rupees, it could be the imprisonment, it could be both, right? So what you need to learn, you just need to learn about the particular cases, what is being happening under which section and which part of which section, and then you need to remember about these important amounts, right? You need to remember about the amount also, and the duration to which the person has to serve the prison. So all these things are the important points inside this. Moving on, we are just talking about the section 66E. Then again, we have got the penalty amount and also just the number of years, right? What is happening inside this, that it provides for intentionally capturing, publishing or transmitting the image of private area of any person without the consent, right? If the person is doing any such kind of the act, then he has to pay rupees 2 lakh and the imprisonment of 3 years. Then we have got the 66F inside this. For doing any act electronically or with the use of the computer with the intent to threaten the unity, integrity, security or the sovereignty of the India, right? If the aim is to threaten the unity, integrity, security or the sovereignty of India, then there is the penalty or the punishment is your lifetime imprisonment. So the person should see that even if he is making a crime, that crime should not come under this section 66F, because in that case he is going to be imprisoned for his entire life. Now all these things were coming under the section 66. Moving on, we are going to see what is coming inside the section 67. So the section 67 provides for publishing or transmitting in electronic form any material which appeals to prurient interest or if its effect is such as to tend to deprave and corrupt the person who are likely to read, see or hear matter contained in it. So the penalty is of rupees 5 lakh, imprisonment is of 3 lakh. So what it is saying to us, it is saying to us that if there is such kind of the publication or such kind of the transmission of the information in the electronic form, that is basically for the purpose or the intention behind such kind of the publication or the transmission of the information is that the intention is to deprave and corrupt the person, then in that situation also it is going to be considered as an offense. Means you are publishing some kind of the article or you're just transmitting the information in the electronic form with the intent of corrupting the another person. Means there couldn't be any kind of the thing which is aimed for corrupting the person. That will be also considered as a kind of the crime only, and that also has got a penalty which can be of up to rupees 5 lakhs and which could be also of up to rupees 10 lakh, and all the situations which all these things can be easily read by you all and can also be understood that how much is the amount of the penalty and how much is the duration of the imprisonment, right? Then moving ahead, we are going to go to the important points. All these things are just talking about the sections of the Information Technology Act. We have covered till section number 67. Now they are also talking about the section 72, 73. Means the entire sections which are related to the Information Technology Act and which are related to this cybercrime part are being described over here. Now, section 73 is doing what? It provides that if any person publishes an electronic signature certificate or make it available to any another person. We have learned about the electronic signature. We have learned about the digital signature also. If somebody is trying to steal that thing also, or if somebody is trying to publish your signature certificate also, which will also be considered as a crime only. Means if there is an electronic signature and anybody is using your electronic signature fraudulently, then that is also going to be come under your offense only, right? And then you have got, obviously, if there is an offense, there is going to be penalty, there is going to be an imprisonment, and there could also be possibility of both the things. So the penalty could be of rupees 1 lakh, imprisonment could be of rupees 2 years, right? Or both the things could be there. So I think now, as we have covered some of the sections, from not all the sections, I have left 1 or 2 or 3 sections which could be easily understood now, because in all the sections there are 3 important things which are being written. I'll just tell you how to just grab all the sections or how to learn about all these sections. First thing is that you must remember the number of this section. Means you're talking about the section number 43, you're talking about section number 44, 70, 71, 66, and so on, right? First thing is to learn about the number of the section, right? Second thing is to know the important point in that section. For example, if I'm saying that you need to learn about the section number 72A, what you need to learn, what you need to understand that in section 72A, it is talking about the electronic signature. That's the only point which should be there inside your head, which should be there inside your brain. Now, if you know that section 72A means electronic signature, now you can frame the entire sentence that if any kind of the fraudulent or dishonest, or if somebody is trying to access your electronic signature in an unauthorized manner, then there is going to be then that will be considered under the offense only. Now you have mentioned that that is going to be considered under the offense. Now you need to remember next thing, what? The amount of the penalty and the duration of the years. The amount of the penalty, now you have got the different kinds of the penalties in all the different kind of the offenses. Now that is the thing which you need to remember, penalty amount and the imprisonment years. So that is how you all can remember. Or one thing you all can do is to make a table. Just create a table, and in the first column of the table just write the section. Then in the second table just write the important point about that section. In the third table just write the amount or the penalty amount, and in the next column of that table just write about the duration of the imprisonment. So all these pages which are being written over here now till here, we just started it from here, just remember. So there are 4 or 5 pages which are coming under the offenses. These could be just come under a table only, right? I think this is going to be a better way to learn about all these important sections, because now what you will be just writing, you will be just writing about the number of the section. For example, section number 72, right? What is the offense in that section? You will just write electronic signature. Then you are just going to write about the penalty. Penalty is of rupees 5 lakh. And in the next column, you are just going to write about the imprisonment years, right? So when you are just going to frame a table or form a table, it is going to be very, very easy for all of you to remember this cyber crime wala section, right? It is like a lot of theory kind of thing. You all just can summarize it in the form of the table. Understood?
Yes, ma'am.
Okay. So what
Yes.
I've told you, I've just told you to summarize it in the form of the table, and it is going to be very, very easy for you all, in spite of just going with all these lines and lines of paragraphs. Fine, you all can do that?
Yeah, okay.
Okay. Now, moving on. Now we are going to talk about, they haven't given the main heading, 5.4.1. What is 5.4? Okay, offenses. We have discussed about all the sections in the offenses. Now we are going to talk about the heading under these offenses. Now, liability of the network service provider means now it is also going to be, or something is also going to come on to the network service provider also. Who is the network service provider? Who is the network service provider?
ISP?
Yes. ISP is your, means the person who is providing you the services of the internet, or the internet service provider is an example of that, right? Now we have got the section number 79. It has been written over here that a network service provider means any of the person who is providing you access to the information services in the electronic form. For example, your internet service provider. We all know that who is an internet service provider, right? Now, it essentially performs 2 tasks that we know, providing us the service of network. Now, what is happening in the case of this is section number 79 provides certain exemptions from liabilities to intermediaries, that is internet service provider. An intermediary shall not be liable for any third-party information, data, or communication link made available or hosted by him. This exemption shall apply if the function of the intermediary is limited to providing access to a communication system. Intermediary does not initiate the transmission, select the receiver of the transmission, select or modify the information contained in the transmission, and the intermediary observes due diligence while discharging his duties under this act, and also observe such as another guidelines such as the central government and may prescribe in this behalf. So what we have understood by this entire paragraph is that obviously we are always in need of a network service provider, or we are able to access the internet when we just have the services which are being provided to us by an internet service provider. Now, when we have this third party sitting between us and the data, now he should also be a responsible intermediary. He should not be doing any kind of the things which are not legal, because he's sitting in between. He's providing us the service. So he's limited to providing the access to the communication system over which the information is being made. He should not do a number of the things. The intermediary cannot, or I will just use the term ISP, right? ISP does not initiate any kind of the transmission. He is not responsible for selecting the receiver of the transmission. Means the ISP cannot initiate the transmission of the data, and ISP cannot select who is going to receive that data. He cannot just do this activity, right? After that, he can also do not or cannot modify the information that is traveling into the transmission, that is traveling onto a network. He cannot do any kind of the modification onto that, and he cannot just means ISP should be a very, very responsible party. He should be a very responsible third party, and there are a number of the do's and don'ts that are being present into your section number 79, what all the ISP can do and what all the ISP cannot do. Obviously, any kind of the activity that is coming under the for example, that any kind of the activity such as the transmission of the data or the receiving of the data, or the activity that is related to even if he's discharging his duty, then also he has to follow the certain guidelines which are being provided by the central government. Then all these things needs to be followed by the internet service provider. Means inside your Information Technology Act 2000, not even the internet service provider is being left. He's also being covered, because he's an intermediary. He's providing certain kind of the services. So there is a requirement of the existence of various kind of the laws that he also needs to be followed, right? So there is a whole set of the list which includes the do's and don'ts by the ISPs, which needs to be followed by the internet service provider. All these things are being written over here, and I have also read them also and make you understand about all these points also, that what he can do and what he cannot do in this section. Next is your investigation part. For the purpose of conducting the cybercrime investigation, essential special skills needs to be present inside the technical team. Right after the commencement of the Information Technology Act, some provision of Criminal Procedure Code CPC 1973 and the Evidence Act 1872 have been duly amended. Along with these, certain new rules and regulations had been imposed by the Indian legislature to meet the need of the cybercrime investigations. Now, in the case of the investigation also, it has been written very, very comprehensively in the case in your Information Technology Act 2000, that what are all the essential skills, what are all the technical tools, what are all the essential things which can be required in the case of the cybercrime investigations. So when earlier they were mentioned into your Criminal Procedure Code and your Evidence Act, now everything has been included into your Information Technology Act 2000, and for the purpose of the investigation, whatever is being required, all those things should be available, whether a technical team or a forensic team, or whether the specialized skills person are required, or whether there are any kind of the tools and techniques which are required, then they all should be present with the investigation team. As we know that cybercrimes do not know any boundary. A person sitting in one country can commit the offenses and having its consequences in the another country. So the section 75 provides that if any person have committed an offense or contravention committed outside India, and if the act or the conduct constituting the offense or contravention involves a computer system, computer network located in India, then the provisions of this act shall apply also to any offense or contravention committed outside India by any person, irrespective of his nationality. What it is saying that the section 75 is explaining to us that the cyber crimes are boundaryless crimes because they are being performed onto the cyberspace, and the cyberspace do not have any kind of the boundary. So if one person is sitting in one country and he's making any kind of the offense, that offense is affecting to the computer system or to the organization or to the individual or to the society of another country, then that person is being, then the act or the provisions of the act is being applied onto that particular person who has committed the crime outside India also. It is not like that I am sitting in India and I can make any kind of the cyber crime to any another country in the world, and because I am sitting in the India, so there would not be any kind of the punishment given to me because I haven't made any kind of the crime which is affecting India. No, it is not going to be happening like this. If your crime or if your activity or if your act is affecting any of the country in the world, then you will be sued by the court of India only because you are sitting in the country, in this country, and then you are affecting or you are doing such kind of the activity which is affecting any of the society in this entire world. So that is being considered under your section number 75. What section number 77 is doing, it provides that compensation, penalties or the confiscation shall not interfere with another punishments. Means there are certain another kind of the punishment, they should not be merged or they should not interfere with the another kind of the punishment. Your compensation is another kind, penalties are another kind, confiscations are another kind. Penalties or confiscations are one and the same thing. Then they should not interfere with another kind of the punishment. If the court has decided that this is the another kind of the punishment that is being given to this particular person, then they should not interfere with the compensations or the penalties. Right. Next is your cyber forensic. What is cyber forensic? It is a process of your acquisition, authentication, analysis, and documentation of the evidence retrieved from the system or the online used to commit the crime. What is happening in the cyber forensic process? Cyber forensic is also known as your computer forensic. What it is doing, it is basically the process of your acquisition. First of all, acquiring whatever document, whatever evidence you are getting onto the crime site, right? Then authenticating it and then analyzing and documenting all the evidences that have been retrieved from your system or from the online data which has been used during the time of performing the crimes. So that is coming under your cyber forensic. This is the team of the people which is performing the process of acquiring the data, authenticating the data, analyzing that data, and then from where? From the crime scene or from the crime system, from the computer system on which the crime has been performed, or from the online database also. Right. Then the system could be from the computers, it could be from the networks, it could be from the digital media or the storage devices that could contain the valuable information for the investigator to examine. So cyber forensic team just visit that particular site and it take all the possible, all the possible evidences that could be in the form of your computers, networks, digital media, or the storage devices that can be used for storing the particular information. From online, it could be from e-commerce domains or the another website also. In this cyber forensic, the file or the data carving techniques are most commonly used. Right. So cyber forensic is basically doing with that. It is basically retrieving all the data and then it is analyzing that data. It is just, for example, some data is being deleted. It is try to retrieve that data. If some files are being hidden, then also if the cyber forensic team is going to recover those files. If you have deleted, then the team is going to retrieve that files. So basically the cyber forensic helps solve the issue of recovering of the informations from the files where the file system is being unavailable or the file system structure is corrupted. Means if the criminal has made any kind of the modification in the system, Whether he has hidden the file, he has stolen the files, he has deleted the files, he has corrupted the entire file structure. Now it is the responsibility of the cyber forensic team or the cyber forensic expert to retrieve that information, to recover that information, and then that information can be used as an evidence whenever the case is being filed against that particular person or the organization or the person who has made all this kind of the offense. So that is basically come under your cyber forensic thing. Now there are various tools which are available. Cyber forensic investigation tools or the cyber forensic technique includes all these things. There are these important points. First is your cross driven analysis that correlates the data from multiple hard drives, right? Multiple hard drives data is being taken, and then there is a cross driven analysis or the relation is trying to be established among the data which has been acquired from the various hard drives. Now the live analysis which obtains the data acquisition before a PC is shut down, right? Before a personal computer is being shut down, then there is a live analysis technique is being also performed, then deleted file recovery, then detecting the data theft using the stochastic forensic, then concealing a file, message, image, or video within another file using the steganography. So all these are the various techniques and tools that are being used in order to recover your data, in order to just retrieve your files and file structures. Now, computer forensic investigations go through 5 major standard digital forensic phases. These are all the phases through which your forensic team is going to go. And by applying all these phases, they are trying to find the digital evidences, right? So first is the development of the various policies and the procedures, then the assessment, then the acquisition of your data, then the examination of your data, and the reporting. So these are all the basic 5 major standard digital forensic phases. So a forensic team is going to go through with all the important phases with all the steps, and then they're going, at last they are going to generate a report, or they're going to make a report about the cybercrime that is being performed. First of all, they're going to form the policies and the procedures. Then after that, they're going to access. After that, they're going to do the acquisition, do the assessment, and then the acquisition, and then the examination is going to be performed, and after that a report is going to be generated. So moving on. So all this is being covered inside this unit. We have discussed about, at last, we talked about the cyber forensic, what comes under the cyber forensic, what are all the investigation tools, right? After that, we have also, before that, sorry, we have also discussed about your section 77 that comes under your investigation part, or how the investigation is being performed in the case of the cyber crimes. Then we also talked about offenses and the types of the offenses, inside which we have also covered the section of the liability of the network service provider. All these sections have been discussed in detail, what comes under your section 72, section 72A, section number 73. Then before that, section 67 is also being discussed, section 66F, and all the parts of the section 66A, B, and C. So that comes under your offenses. Then the appellate tribunal, what is an appellate tribunal and what is the function of this appellate tribunal? Then who is the adjudication and what is the function of this adjudication, and what he has to do whenever an adjudication is being appointed. Then before that, we also discussed about all the points and which are coming under the penalties and the compensations, right? What is coming under the section 43, 45, mainly section 43 points have been discussed. Now moving on, after all these things, or whatever is coming into your cyber crimes, about all the kinds of the penalties, the compensations, or both, and what is coming under which section, we have to move on to the next part, which is your intellectual property rights issues in your cyberspace. IPR is basically intellectual property rights issues into the cyberspace. Now, what are all the intellectual property rights? The term intellectual property rights can be defined as the intangible property, means the property that is being created by one's mind only. It is not necessary that that property, it is not merely an idea, but an expression of that idea. It could be in the form of the music, literary, artistic work, any kind of the inventions, design, symbols, names, and images, right? So all these things come under your intellectual property rights, and we do have the rights related to these intellectual properties. So I'm going to just explain you again about this intellectual property term. Intellectual property, intellectual means something that is being originated by your brain, by your mind, right? So that kind of the property which has arisen out of your intellect is called as your intellectual property. Any kind of the intangible property which has arisen because of your brain, which has arisen because of your mind, is going to come under the intellectual property. What it can include? It can include the music, it can musical work, it can include the literary work, it can include the artistic work, it could be any kind of the invention, it could be the any kind of your designs, symbols, names, and images. So all these things are being considered under the intellectual property. And what is intellectual property rights? Intellectual property rights are the set of those rights that are being given to the particular person, which are saving your intellectual property, because that property is being generated by your brain. So that is related to you only. And those rights which protect your intellectual property, they are called as your intellectual property rights. Rights that are being formed to perform the function of saving your intellectual property are called as your intellectual property rights. Understood about the intellectual property?
Yes.
So kindly repeat what I've told you about intellectual property. What is intellectual property? Intellectual means? Tell me what you understood by the intellectual property. Intellectual property means you are telling or I should tell?
When we make something using our own brain.
Right. Anything in, just break this word, intellectual and property, right? That means there is a kind of the property which is being formed, created, right, invented by using the mind of one person, which is an outcome of the mind of any of the person. So that kind of the property is called as your intellectual property, because it is not necessary that there are two kinds of the property. We have got the tangible and the intangible property. In the case of the tangible property, what we have, for example, the house is a property, the land is a property, the ornaments or the gold are the properties, right? Generally, we consider all these items or all these things in the category of the property only, right? But these are, the land is not the creation of anybody's mind. So that is why it is coming under the intangible property. Your house is not the creation of anybody's, it is not the creativity of any person, right? Your gold ornaments. So all the tangible things to which we all can touch and they all can be destroyed will come under your tangible properties. Whereas in the case of the intangible properties, they are going to be come under the category of your intellectual property, because that property is being created by your brain. Just read this line: creation of one's mind. Any property which is the creation of one's mind is considered as your intellectual property. Now we are going to talk about the various forms. What are all the forms of IPR? Means the types of intellectual property. There are basically 7 types of the intellectual property. We have got the copyrights and the related rights. We have got the trademarks. We have got the patents. We have got the industrial design. We have got the geographical indication. We have got the trade secrets and the plant variety. So these are all the 7 types of your intellectual property. So any copyright, any trademark, any patent, any industrial design, any geographical indication, any trade secret, and any kind of the plant variety will be considered as your intellectual property. So what are all the copyright? So what is the copyright and the related rights? A copyright is used to protect the creative, literary, musical, dramatic, or another artistic works like cinematographs, films, and sound recordings, inclusive of the musical composition, audio recordings, paintings, photos, sculptures, books, articles, diagrams, movies, website content, and even the computer software and the programs through the inventions related to software are protected though the inventions related to the softwares are protected under the patent law. So all these important things, whether any of the creation which is related to your literary work, you have written something, for example, you have written a poem by yourself, right? So what you can do, you can just go to the copyright authority and you can take a copyright of your poem. That means this particular poem is mine. I have created this by making use of my mind. I've created this by using my own brain. So this poem is just mine. So if there is any kind of the literary work, you have written any kind of the literature, any kind of the music that is being created by you, any kind of the drama or another artistic works, it could be you have created a film, you have just recorded any sound, right? Any kind of the musical composition is there, audio recording is there, paintings are there, photos are there, sculptures are there, books are there, articles, diagrams, movies, website content, and even the computer software and the programs, they all are being saved by making use of the copyright law, right? They all are coming under the copyright category. You have your audios, you have your videos, you have your literature, you have your music, you have your drama, you have your computer software and the programs. If they belong to you, you can have the copyright of them. You can have a certificate that all these works are being generated by me, or all these works are being created by me. That is why they are mine. So give me a copyright, right? Copyright means, you understood now, na? Any kind of the rights that are being related to all these important works, you can go and take a copyright. Fine. Now, what are all the rights granted? The rights granted are, means the owner who has created such kind of the work, that owner has got the exclusive right pertaining to reproduction and distribution. What right the copyright person will have, it is just his own choice whether he wanted to reproduce and distribute his work or not, right? It is his choice whether, for example, drama, in the case of the drama, I'm a person who has created a drama, right? Now it is my choice whether I wanted my drama to be performed publicly or not, right? Now, means any kind of whatever I wanted to do or whatever I do not wanted to do with my work, now it will be like my choice. Now I have got the right onto my work. Now, no, if I do not have the copyright, another person can come and can just steal my own composition. For example, I made a musical composition and I haven't taken the copyright of that musical composition. What can happen? Another person can come and can use that musical composition, and I will not be like the whole sole owner. I will not have any exclusive right onto my composition, in spite of me being created that composition. So if I wanted to have the right onto my work, if I wanted to claim that this work is my own, that then in that situation I can just take the copyright of that particular work, right? And what kind of the work is being included in the case of the copyright? The kind of the work should be the creative literary kind of the work, the musical, dramatics, sounds, audios, paintings, photos, sculptures, books, articles, diagrams, computer software, and the programs. So all these things are coming under my copyright, and these are all the rights. Now, what is coming under the patent? Patent is again the another kind of your intellectual property. So the patent is an exclusive right which is being granted to protect an invention, which could be a product or a process, and can also be applicable to the newly engineered plant species or strain, however a discovery. Now, what is happening in the case of the patent? I can, for example, I have invented a particular product which is very specific, which is very new. It has never been invented, right? Or if I have tell you about, for example, SDLC process, we have got the software development life cycle. I can take if I am the person who have generated that SDLC, then I can take a patent onto that particular process, because that is a very new process that is not being existing into the environment earlier. So if I have generated or if I have invented a product or a process which are very new into the nature, then in that kind of the case, I can take a patent from the patent authority. The rights are territorial in nature and the patent protection is granted for the limited period, right? Now, when a invention is patentable, an invention is patentable only if that invention is novel in nature, it has got the inventive step and capable of industrial application. Now, how it will be decided that whether my invention is patentable or not, means how I will decide that. For example, I've created this particular product. I wanted to go for the patent for my particular product. Now, how it will be decided whether that particular product will be patentable or not? These are the three important steps. First is my product should be novel in nature. It should be new. There should be kind of novelty into my product. Now, second thing is it has got the inventive step. Inventive step means it should not have any of the phase which is like obvious in nature, that nobody should claim that if this step is being performed in the development of this particular product, then this is a this step is obvious in nature. So the non-obviousness should also be there. And the third thing is the capable of industrial application. Whatever product I have invented, whatever product I have developed, it has got the certain kind of industrial application. So if all these three important points are checked, if this checklist of novelty, non-obviousness and industrial application is present into my product, then I can go to any patent authority and I can go for the patent for my particular product. Now, when I will have the patent of my particular product, I will have the right onto my product or the process generally for 10 years. And after that, it could come into the public space also. Means the rights are depending on to the country specific. They are country specific. Every country have their different kind of the rights for the intellectual property. India can have their separate rights which has got the different kind of the definitions. Any another country can have their separate rights which can have any another definition. So for the right parts, it depends on the country to country what kind of the rights are being given onto the case of the patents, what kind of the rights are given into the case of your for example copyrights or the trademarks. Now that covers the section of your patents. Moving on to the section of your trademark. What is a trademark? Any of the distinctive sign or symbol or mark or word which is identifying my particular goods or services will be considered as the trademark. Now just imagine all the large companies or all the large organizations have got their brand name, have got their signature, have got their logo, right? Have got their slogans. What we do, we just see the slogan and we just understand that this is the slogan of that company, or we just see the logo and we just understand. For example, we all will be able to recognize the logo of McDonald's, right? We all know how the logo of the McDonald's looks like. So all such organizations, means if there is an organization, that organization need to have its trademark, need to have a logo, need to have a brand label, need to have a slogan, need to have a letter. And when we are talking about all these things, because these logo, these signature, these name, these brand, they are just distinguishing your a particular product, they are distinguishing your goods or services. They are becoming easier for the consumer to identify their product. So what all are these logo, brand, signature? What are all these marks? These all marks are called as our trademarks, right? Whether it is whether there is a mark which is in the form of a symbol, which is in the form of a word, or a special mark is being used in order to distinguish the particular goods or service, that kind of the mark is called as your trademark. Now, again, registration of your trademark is valid for the specific period and needs to be renewed also, right? The trademark, whenever we have got a trademark, it is a thing in that it needs to be renewed, and it depends on the country to country that in how much duration the trademark needs to be renewed. Now, the fourth kind of the intellectual property right which is available to us is our industrial design. Industrial design means now we are going to talk about the shape of the object. Now we are going to talk about how the particular product looks like, right? How the appearance of my article is going to be. So when we are talking about the looks, when we are going to talking about the shapes, or when we are talking about the appearance of my product, then In that case, the kind of the intellectual property defined is called as my industrial design. So what it talks about the it talks about the appearance of a product or the logo. It talks about the shape of an object. It talks about the composition of the design, pattern of the cloth. The industrial design may have three-dimensional features such as your shape or the surface of an article, or the two-dimensional features such as the patterns, lines, or colors. So it could be three-dimensional also. The design could be three-dimensional also, and the design could be two-dimensional also. In the case of the two-dimensional, mainly patterns, lines, or colors features are being considered, whereas in the case of the three-dimensional, the shape or the surface of an article is being considered, right? Industrial design means we are talking about the appearance, we are talking about the shape and the size, and we are talking about the looks of any of the particular product. Now, for the production of an industrial design, it must be new or original and aesthetic and requires the mandatory registration. Obviously, for protecting our industrial design, there is always a requirement of the registration of your industrial design, and any design will be considered as an industrial design only when it is going to be new or original in nature, and it is going to be aesthetic and requires the mandatory registration. Then next kind of our intellectual property right is our called as the geographical indication. Now, the geographical indication is basically a product which is specifying or which is being produced from any particular region or the location. Then that kind of the product is called, then that kind of the product is going to come into the category of the geographical indication. Geographical means it is going to specify a particular region, a particular location in the geography. Means now we are going to talk about a particular country and then the particular region of that particular country. When a special kind of the product is being produced by a particular region of a particular country, then that particular product is going to come into the category of your geographical indication. For example, now we know that, for example, the rice crop. There is a region in India. Let's talk about the Dehradun. Dehradun is a particular region in India. There is a special kind of the rice which is called as a basmati rice that is being produced in that region only, because for example, the climate of that region, the soil of that region, or all the another environmental factor of that region favors the production of the basmati rice. Then we say that this is the basmati rice and this has got the geographical indication of Dehradun only. And Dehradun is in which country? It is in country India. So when any particular product is specifying to us, or when any particular product is indicated towards a geographical indication, it is a specialization of that geographical indication, then that product is going to be registered under the geographical indication intellectual property. Now, what all could be included into your geographical indication? It can include or typically used for the agriculture product. For example, I have given you an example of the basmati rice only. It can also include the foodstuffs, wine and spirit drinks. It can also talk about the handicrafts and the industrial products. For example, it is also being written over here, basmati rice, Swiss watches, Ethiopian coffee, then tequila for the spirits produced in your Mexico, electrical appliances made in UK. So we can see that with the name of the product, the name of the country or name of the region is also being associated mostly, right? So when the name of the region or when the name of the country is also being associated, then the geographical indication is being given to that particular product, right? Now, in order to function as a geographical indication, a sign must identify a product as originating in a given place, and the qualities, characteristics, or the reputation of the product should essentially be due to the place of the origin. Next, we are talking about the trade secret. Trade secret is any confidential trade, and trade secret is another kind of the intellectual property, and it is any confidential secret information having the inherent economic advantage to the company and is used in the business that gives a competitive edge by reason of it being secret. For example, my grandmother has got a particular recipe of making the pickles, right? She knows the recipe of the how to just make the pickles, right? Then in that case, that recipe is being transferred to me only because I'm an inherent successor of my grandmother. Now, I could just make my recipe as a secret and I will just start my company of manufacturing the mango pickles, right? But now I will not leak my secret recipe to anybody. I'll just manufacture the product into my organization, into my company, into my industry, and just kept on selling my product in the market. Now, if anybody wants to know how my mango pickle is being manufactured, what is the recipe behind my specialized mango pickles, now I will not tell it because I have protected my mango pickle recipe under the trade secret. So in these kind of the situations, whenever there is a particular kind of the formula is there, any particular kind of the practice is there, programs are there, any particular kind of process is there, recipes there, patterns are there, techniques are there, compilations, methods, devices, or the product mechanism are there, then what I'm going to do, I'm going to just save this confidential information. I'm just going to keep this confidential information as a secret only. So it is going to be covered under my trade secret protection. So in order to get qualify under this trade secret protection, no registration is being required. However, to protect the trade secret having commercial value, the business must limit the number of the person who knows or access the information. What is coming under this? There is a non-disclosure agreement that is being signed that only these are the number of the people which are going to know about my formulation, about my practice, about my program, about my process, recipes, patterns, techniques, compilations, and so on, right? So these are all my 6 kinds of the intellectual properties which are there in the which are being present, right? So what I have discussed about, I've discussed about the copyrights, I've discussed about the patents, then trademarks, geographical indications, industrial designs, and also about the trade secret. Now, the lines that we are going to see about that, there are some categories of the intellectual property that needs law to regulate the protection of the intellectual work into the cyberspace. What are all them? They are intellectual works in the digital form can easily be replicated. Intellectual works in the digital form can easily be transmitted. Intellectual works in the digital form can easily be modified and manipulated. Intellectual works in the digital form can easily be formed in resemblance or equivalence can easily be created. One can easily search anything in the digital space and link their own work with someone else's work. Now, why we are talking about the intellectual property in the cyber space? Because nowadays what is being happening, a number of the work that is being created in the hard copies are being now converted into the digital form. Now, when your work is being converted into the digital form, there is always a risk of the easy replication of your work. For example, you have written your poem and you have just transferred that poem into the cyberspace, right? You have made it public. Now, what can happen? Anybody can steal your poem because you have not protected it. You have not protected it with the copyright. So in this case also, a number of acts are being present into your Information Technology Act that talks about any of the work. It should not be replicated easily. It cannot be it should not be transmitted. It should not be modified or manipulated. It should not be resemble. There should not be any kind of the resemblance with any another work, and it should not happen that some person just link his own work with your work and says that it is mine. It should also not be the criteria. That is why we also have the intellectual property rights for the cyberspace also, and all these rights are being written under the various sections in the Information Technology Act 2000. What I'm saying that your digital work or any of your, whether it is a picture, whether it is a musical composition, whether it is a song, whether it is a sound, whether it is a drama, whether it is for example, it could be any article, right? All these things could be available online also. So there is a requirement, and all these things are related to your intellectual property only, right? So there is a requirement of the various acts so that all these things cannot be stolen from your cyberspace, and there shouldn't be any person who just remove your name and just write his name and say that this is the poem that I have created. but actually it's not been created by him, it's been created by you only. That is why we have got the various intellectual property rights for the cyberspace only. So that is all being covered inside this intellectual property rights and the cyberspace or the cyber security that should be given to this particular topic. We must know about all the types of the intellectual property rights. We must know about what can happen to our data whenever it is presented into the digital form. It can be replicated, transmitted, modified, manipulated, have got the resemblance with any of that person, and it could also be linked with the work of the another person also. So all these things are being covered inside this. So with that, we are coming actually on to the end of this lecture. So in this particular block, you must know about the cyber crimes. What are all the cyber crimes? What are all the sections that come under your cybercrime things? And what are all the kind of the penalties that could be imposed onto the person? And what are all intellectual properties, types of the intellectual properties and the rights? And then why it is necessary to have the cyber security in the case of the intellectual properties, or what are all the issues that could arise into the cyberspace also in terms of your intellectual property rights. So all these things needs to be learned. Now what you need to do, you need to just first of all just summarize all this data in the form of the table, right? Just you have to just go through with all the data once, summarize that in the form of the table, make all the notes and just keep it with yourself. Next time you need to revise it, just revise the table and it will be very, very easy for you all. And in the case of the intellectual property rights, you just need to remember the types of the right, and you just need to remember what is the copyright, what is the trademark, in which case the trademark is given, in which case your geographical indication is working for what, your trade secret is working for what, your industrial design is working for what is a patent, and how the patent is being done, and why you always require all these why you always require the protection of your intellectual property rights in the case of your cyber space. So these are all the things which are being presented in this particular PDF, and I hope we are done with this for today. If you are having any kind of the doubt, any question, then you can ask me.
Ma'am, excuse me. Shall we, I mean, make up all, memorize all the sections and acts which are written in our book? I mean, they're in our book.
That's what I'm telling you.
That will be
Obviously,
really difficult, ma'am.
yeah, it's going to be
Other
very difficult.
concepts will be a bit clear. We can take from other parts. I mean, concept of other parts, but for sections, it will
Yes,
just
yes,
we need.
yes.
But just it will. We couldn't just take a concept. So just making up that. That's
Yeah.
it.
Yes, yes. Obviously, this part of this particular subject is actually making us all aware about the particular sections and what is there in that section, and what is the kind of the punishment that could be given to the particular person. But as we are seeing that there are a lot number of the sections which are being written into your particular book, that is why I've suggested you this short method of remembering the sections, and you can just break the table also into the separate tables. That section 43 to 60 will come into this table, and then 60 to 70 will come into another table. Obviously, if they are being written, so they can be asked into your examination also. And then in that case,